Hello and welcome. Thank you for joining us today. My name is Maureen Pace and I'm the president of the World Trade Center Dublin. As part of our Get Ready to Be Ready webinar series, today I'm excited to have you learn from our esteemed speakers who will talk to you about how SMEs can protect their intellectual property when exporting. So I'm going to turn it over now to someone who many of you know and talk to on a regular basis, Tig Morris. Tig is part of our account management team, and on a daily basis is helping companies to grow their networks and to grow their business opportunities. So with that, Tig, I'm going to hand it over to you, and I look forward to learning a lot today. So thanks everyone for being here, and we look forward to seeing you again soon.
Thank you, Maureen. Thank you. I'd like to once again thank all participants and thank you all for joining us this afternoon. As our participating member companies will be well aware, the World Trade Centre Dublin is part of a global network of over 330 trade centres around the world. Our prerogative here is to assist SMEs across Ireland in every stage of their export journey by utilising our expertise and global network. One of the most crucial stages of that journey is making sure that your brand, products or services are protected overseas, which is why we are here today with attorneys Dennis McCarthy and Carla McLaughlin of McLaughlin and Donaldson, one of Ireland's leading intellectual property firms. Dennis and Carla will be speaking about the fundamentals of intellectual property, its different elements such as trademarks and patents, and what to consider when developing your export strategy. If you have any questions on any of the topics throughout the presentation, please pop them in the chat box at the bottom of the screen and we will get to as many as possible at the end of the presentation. So without further ado, I will leave you over to Dennis and Carla.
Okay, so we'll just begin. My name is Carla McLaughlin and I am a director and a trademark attorney at McLaughlin and Donaldson. Today we're going to discuss how SMEs can protect their intellectual property when exporting, as Tig has said. So if we just move on to the first slide, we'll be able to get going. So on the agenda today, we're going to discuss what is intellectual property and the different types of intellectual property and exporting, so international patent applications, international trademark registrations, and international design registrations. We'll also hopefully give you some intellectual property strategy takeaways and points that you can take home and with you and remember for the future, and also some intellectual property supports that are available to SMEs. So perhaps we could move on to the next slide. So firstly, what is intellectual property and the different types? So we have trademarks, designs, trade secrets, patents, and copyright. And the next slide, please. So this slide tells us the different, I suppose a more in-depth explanation of the different types of intellectual property. So a trademark identifies a product as being from a particular company or a person. So it is the brand, it is what we see when we look at a particular product, and certainly even when we look at a service, if you look at a website, you see it is the brand or the trademark that is there to be seen. A patent protects the function of a product. A design protects how a product looks. Copyright protects literary and artistic works, and trade secrets protects a company's know-how. So some secrets, maybe a secret recipe that is only known to that particular company. Next slide, please.
Thank you, Carla. I think this is where I come in. My name is Dennis McCarthy. I'm a director of McLaughlin and Donaldson. I'm a patent attorney and I concentrate mainly on patents and designs. So before we go into the actual specifics of each element of intellectual property, I think it's useful just to take one overview of the role that IP has in enterprise development. And there are a few key messages that we'd like to get across to you today. And we start there at 12 o'clock on the dial. it's well known that IP is an integral part of any successful business, and it's been well proven as a strong link between IP protection and economic growth. And this applies both at the macro level for countries and economies, as well as for individual companies. And another fact which is well proven is the revenue per employee is higher, especially in SMEs, when the IP is protected. So the role of an IP is obviously to protect your current and your future marketplaces that you may wish to export to. By having your IP protected also opens the possibility that you could license third parties in other countries, because you may not be feasible for you to exploit that particular market by exporting alone. So, and the final message that we really like to get across is that you should consult an IP advisor. I would advise strongly against doing this on your own. It's something that you need professional help, because this is quite a complex area and the laws are quite different in different countries. So now, having had this overview, I'll hand you back to Carla again, who's now going to start dealing on trademarks.
Thanks, Dennis. That's great. Thank you. As Dennis said, I'll concentrate on trademarks now at the minute. So I suppose we want to figure out what a trademark is. As I've said, it is that brand, it is what is seen on a product, or as I said, if you're a service, certainly on your website. So it is any sign that can be represented graphically and is capable of distinguishing your goods from those of your competitors. It is an identifier of your goods or services, because as I say, it is the first thing that your customers will see. It is your brand, that's what they'll see, it's your trademark. It is a badge of origin. Also, it's important, and this is where an IP advisor will come in during your IP strategy. When you're developing a brand, you need to know exactly what what your trademark can be, to make sure that it will be registrable. So a trademark must be distinctive, it must be unique, it must be different. It cannot be confusingly similar to your competitors' trademarks or to any third party trademarks in the same area of business. A trademark has a registered trademark has an unlimited term of protection. It can be registered. It can be renewed, I should say, every 10 years for as long as is required. A registered trademark is much easier to enforce. So when you register your trademark, you have your certificate of registration. You have a piece of paper that says that you have a monopoly in that sign, and therefore you can prevent others from using a confusingly similar sign. If you don't have your trademark registered, you don't have that certificate of registration, and therefore it's more difficult to prevent somebody else using a confusingly similar mark if you don't have it registered. Again, trademarks are territorial, and to maintain a registered trademark, it must be used. It has to be used. So if we could go on to the next slide, please. So in the last slide, we figured out what a trademark can be. In this slide, we're going to just identify some elements that a trademark cannot be. So it cannot be descriptive. So for example, you couldn't register the word car for cars, because that would be descriptive. So it must be distinctive. It cannot be descriptive. It cannot be generic. It also cannot be deceptive. So for example, if you sold ice cream, you couldn't call your ice cream Carla's vanilla ice cream if in fact the ice cream is chocolate ice cream. That would be deceptive. And of course, it cannot be contrary to accepted principles of morality. So these are is information that perhaps you may not know unless you engage a trademark advisor. So it's why it's always important to engage an advisor from the beginning of your journey, so that you get all the elements in place and correct. So if we could go on to the next slide, please. So here's just an example of some trademarks. And as we said before, it can be any sign that can be represented graphically. So here we have words. We have Tato, famous trademarks: Tato, Brennan's Bread, and McVitie's. But also we can see logos can be registered as trademarks. So we have the Nike swoosh. We all know that. If you've sons like myself, you'll be inundated buying Nike gear. But so we all know that Nike swoosh, that's a logo. The harp is a registered trademark for Guinness. And of course, the Apple sign for computers. They're logos. So a trademark can be words or it can be logos, or it can be a combination of both. Also, shapes can be registered as trademarks. We have the Coca-Cola shape and the Toblerone shape. Colors can be registered as trademarks. Slogans are quite, there are a lot of slogans being registered these days. So a famous one, obviously, we all know is "Have a break, have a Kit Kat." Just do it again, the Nike slogan. And sounds and movements. All of these can be registered as trademarks. So the next slide, please.
So the next slide, thanks, Carla, comes back to patents. So I'll take over from here. So on patents, well, what is a patent? A patent, it's basically a legal protection that provides the right to exclude others from performing a certain activity. It's exclusive to you in that particular territory. It has to be in a territory, but it is only for a limited term. You have to pay an annual renewal fee to keep a patent in force. And if the renewal fees are not paid, the patent will lapse, so it could lapse early. Now, as part of the bargain and getting a patent and exclusivity and a monopoly granted by a patent, you have to make a full disclosure of the invention, so that when the patent lapses or expires, third parties can put the invention into effect by following the instructions which you have given in the patent application. So patent applications are published 18 months from their first filing date. So once the application is published, it's then in the public domain. So you have to be very conscious of this, that when you file a patent application, you're under an obligation to disclose all the details of your invention. And a patent has a maximum life, unlike trademarks, is a maximum life of 20 years. Trademarks can effectively last forever, but unfortunately patents will expire after 20 years, and there's no extension possible. So if you go on to the next slide, you'll see there's there are certain limitations of patent. A patent is slightly different to a trademark. A trademark gives you the right to use the trademark, but a patent does not give you a right to use the invention. It just gives you a right to prevent others from using your invention. And it could be that your patent is dominated by an earlier patent, and you may not be able to use your patent until the earlier patent expires. So you always have to be careful that you don't infringe someone else's patents by putting your own invention into effect. Now, patents obviously are national rights, and they can also be regional rights, like in Europe or in Eurasia. But they have to be enforced at each country on a national level. So if we go on to the next slide, then we go on to the next aspect of IP, which is designs. Designs are registered designs. They protect the external appearance of a product, the shape, the color, the texture, and in effect the aesthetic appeal of a product. You're not considered with the function or how it works. It's just how it appears to the public. But your design must be novel, cannot have been done before, and has to have individual character. And again, it is territorial. You have to do it in country by country or territory by territory, depending on where you wish to have your markets. As with everything else, we've seen there's certain exceptions to registrability. You cannot register a design which is regarded as being contrary to public morality. You cannot get a design registration for a computer program. And you cannot get a design registration for an item which is purely functional features and has no aesthetic features. And also cannot get a design registration for an item that must fit some other item. And this is because the designer has no design freedom, and he or she has to make the design to fit another article. So that does not qualify for design registration. So I think that goes back to you, Carla, next. Oh, sorry, before we go on to that, we're just going to have a little poll. So we'd ask people if they would, if your business has a registered IP at this stage. We're talking about patents, trademarks, registered designs. So there's a little poll there, if you could fill it in, please. Thank you. Now, Carla, I think you're next.
Great.
Just give people a few minutes for that, I suppose.
Yeah. Okay.
So I see there's a vast majority of people don't have any registrations, designs registered. So the 70% do not, whereas 30% do. So that's interesting.
Yeah, yeah. Very interesting, Dennis. Yeah. Okay, so the next type of intellectual property is copyright. And what is copyright? So copyright protects the expression of the idea, not the idea itself, but the expression of that idea. It is an economic right. It is a moral right. It is owned by the author or the employer of the author. And it's important to mark the works with the copyright symbol and your name and the year that it was created. Next slide, please. So as with all intellectual property, there's limitations. So the limitations to copyright are that it protects only against copying. It is difficult to enforce copyright, your copyright right. So because of that, it's important to make sure that you keep good records and that you get written agreements in case of collaboration, so that it is clear who exactly owns the copyright. I think it's back over to you now, Dennis, for trade secrets.
We're now going to deal with trade secrets, which, like copyright, is another IP that is not registered, but is a very valuable right in itself. And this has been recognized by the European Union, who issued a European directive on protection of trade secrets. So a trade secret is any type of information not generally known or reasonably easy to obtain, by which a business can gain economic advantage over competitors or customers. So that's the formal sort of definition. So basically, the secrets that you have within your organization that are not known to your competitors are part of your trade secrets, and that's something that you can exploit to your own benefit. Unlike patents or designs, it has an unlimited term of protection. However, it's not registered, and it comes into effect immediately once you can document it. And actually, in Ireland, there's actually tax relief available for using trade secrets under known as the knowledge development box, where you can pay 50% of your corporation tax instead of the full rate of 12.5%. You only have to pay 6.25% on profits generated from a trade secret, which qualifies for as part of the knowledge development box. In the next slide, you'll see then that there are certain limitations with trade secrets, and it is extremely important that accurate record keeping is kept. And these records must be kept under lock and key or in a very secure place. And also, you have to develop a company policy about trade secrets. You have to restrict access to employees, and you have to mark documents as confidential. And you also have to ensure that any employees that leave your employment do not take the trade secret with them, and are not allowed to disclose that trade secrets to any other party outside the company. It can be difficult to enforce, and of course, once it goes into the public domain, it's lost forever, because once it goes public, it's no longer a secret. And the other limitation is it doesn't prevent a third party from filing a patent for themselves, whether they've obtained the information legally or quite legitimately themselves independently. it goes into the public domain, and you cannot do anything about it through a patent application. So we've given some samples in the next slide of, well-known trade secrets. I mean, it's probably in folklore that the formula for Coca-Cola is only known by about 4 or 5 people at any one time, and the formula is kept locked in a safe somewhere in the United States. And the same thing probably is said to apply to the Big Mac special sauce, the KFC chicken recipe, and the formula for WD-40, which we all use to unscrew nuts and oil noisy hinges. And also, of course, a trade secret can be used in a manufacturing process. And we just give one slide there showing a robot. So a manufacturing process that you use to put your products on the market may be protectable as a trade secret. So I think that's where I stop for a moment. And before we move on, we have another poll. So the poll is, does your business have an unregistered IP? These are unregistered trademarks, unregistered designs, copyright, trade secrets. So it'd be interesting if you could answer that poll just for see where we are with this. So here on this, the answer to this one is the majority have unregistered rights. So there are some people obviously have rights that they have not registered, but they have IP in their companies, which they obviously need to protect. So that's 56% of you have IP which is not registered at the moment.
Yeah.
So with that, I think we'll now hand you back to Carla, where Carla go into trademark and more details on trademark registration.
Thanks, Dennis. That's great. Thank you. So so now I suppose we'll talk about trademarks and how to protect them, and where they should be, where you should protect your trademarks if you're exporting. So if we could just go to the next slide, that'd be great. Thank you. So so where you decide to protect your trademarks depends on really what country and markets you sell your goods and services. And there are different options available. And again, this is something that an IP advisor would be able to help you with. What course of action to take, and how to proceed. So the next slide maybe we could move on, please. Okay, so this just really tells us the process that an application goes through before it is registered. So at the beginning, what we would always advise is that a pre-filing search is conducted before a trademark application is filed. And what happens during a pre-filing search is that, so for example, say if you wish to protect your trademark in Ireland, or you wish to protect it in the US or in China, a search would be done of those, the trademark databases in those particular offices, trademark offices. And this would show up any identical or confusingly similar marks to what you're hoping to register. So it's always a good idea to do that pre-filing search. It means that there will be less problems further down the line. So once the pre-filing search is conducted and we decide that the particular mark and we wish to register is free for registration, we then file the application at the particular office. Again, depending on where that is. But the process is more or less the same in each country. So, so after the application is filed, then it is examined by the office, and it's at this stage then that the examiner will decide if there's any queries or objections to the particular trademark application. If there are any queries or objections, then they would, a lot of the time they can be dealt with, not always, but often, certainly your trademark advisor would be able to assist in overcoming those objections. So if there are no objections, then if there are objections, sorry, we try to overcome them. And then if there are none, the trademark then is accepted. The trademark application is accepted and it's published in an official trademarks journal. Once it's published in this journal, there's a period of time then when a third party can oppose your application if they have an earlier right. Now, if an opposition arises, then the application it's important then to obviously try to defend the application against the opposition, and there's different stages to an opposition. But assuming that there's no opposition, or assuming that we were able to defend the application against the opposition, we'll receive our certificate of registration. And once you receive that certificate of registration, you now can place that or in the circle anywhere your trademark is. So on your products, on your website, on your social media, everywhere. So it tells the public that that trademark is registered and it is your property, and you have a monopoly to use that particular sign. So that's just the process of what happens during the life of a trademark application through to registration. So maybe the next slide, please. So the next, now we'll I suppose once we understand the application process through to registration, it's determined now where exactly you wish to protect your trademarks and how, what way to do it. So there are different avenues that you can take. So if, for example, you are using you're selling your goods in Ireland and you're also selling them in the US and in the UK, so you might decide then, or your IP advisor would let give you the right advice to protect your trademark nationally in those 3 countries. So you'd file an application. We'd file an application in Ireland and in the US and in the UK, and then in those national offices. And then you obtain protection in those 3 countries. So, and the next slide, please. Another route to take would be if you're selling your products in all of the EU, instead of filing a national application in each of the 27 countries, we can file one application in the European Intellectual Property Office. And that one application, once registered, that trademark would be protected in the 27 countries of the EU. So that is, obviously that is a fantastic route to take if you're using your trademark, you're selling your goods in more than in a majority, in a few countries in the EU. Of course, we have to remember now that the UK is not part of the EU, so we still have to worry about the UK. We'd have to protect, we'd file a national trademark application in the UK if you're selling products in the EU and the UK. And then the next slide will show us the final route, and that is where an international registration. So you may be using your trademark you may be selling your goods, I should say, and using your trademark in Ireland, in the EU, in the US, in Saudi Arabia, in Singapore, in China. So the best route to take then, if you wish to protect your trademark in, say, I suppose 6 or 7 countries and jurisdictions, the best route to take is to file an international registration. And this is one application that is filed at the World Intellectual Property Office, and you designate up to 100 countries. So you can designate 20 countries or you can designate 80 countries, depending on where you're selling your product and where you want to protect your trademark. And with the international registration, you can file, say, now and designate 10 countries, and then as you expand and as your business gets big, grows, and you're exporting to additional countries, then you can add another 10 countries, say, in 5 years. So you can constantly add on protection in different countries and territories if you file an international registration. So that is another route to take. So, but all of these, I suppose it always goes back to the important factor that your trademark advisor should be part of that whole IP strategy, deciding, where to file, when to file in the different countries, and we can always assist with all of that. So the next slide, please. Which is
back to me, Carla.
Yeah.
So I mean, like trademarks, patents can be registered nationally, and they can be registered regionally, and they can also be done an international application. But I've concentrated on international application because I think it's very useful for a company where you are exporting and you're not quite sure where you're going to file patent applications. So the next slide, please, will show the international application it can be filed through what is known as the Patent Cooperation Treaty. And in short, people call these PCT applications, and this is administered by the World Intellectual Property Organization, which is based in Geneva. It was established about 40 years ago, and it's becoming very popular. The usual route is that people will file their initial application in their own country, and within 12 months, they will file an international patent application, which will protect you in up to 150 countries. It's easier now to list the countries that are not part of the PCT or part of the Patent Cooperation Treaty. Argentina is one, and Pakistan are other. There's a few other small countries. But the important thing, unlike the trademark registration, it's not a worldwide patent. It is only an international patent application. If you go on to the next slide, one of the advantages of filing the application is, while it's pending, it is subject to an international search and written opinion on patentability. Now, for anybody living in Europe, this search and written opinion is done by the European Patent Office based in Munich. For US residents, generally it's done by the US Patent Office. But this international search and written opinion is a very useful document because it will have done an exhaustive search, and there will be an analysis by an experienced examiner who will indicate whether or not a patent should be granted or not for the invention. So it's a very useful document, especially if you want to bring investors on board on the potential patentability of your product. However, if you go on to the next slide, you'll see it has a limited time life. It only lasts for 30 months, 2.5 years from your first filing date. And at the end of this period, 30 months, it must be converted into regional and national applications. So, it's quite expensive to actually file it in 150 countries, but you may pick out the most important countries. You may decide you want to protect the invention in Europe, the United States, Canada, Australia, China, for instance. And, you can then do that, at that stage, which is 30 months from your priority date, rather than have to do it 12 months from the priority date, which was the norm, which happened prior to the PCT being developed. So the big advantage companies see for this is that it delays major expense. It delays expense for at least 18 months and up to sometimes 2.5 years, depending on when you file the PCT application. So also, if we go on to the next slide, I also wanted to bring your attention to international design registration. Again, this is administered by WIPO, and it's meant. If you look at the next slide, you'll see that it's filed through what is known as the Hague Agreement. And in an international design application, you can protect up to 100 designs in the same application. And at the moment, there are 90 countries which are party to the Hague Agreement. Unfortunately, Ireland is not in the Hague Agreement, but the European Union is. So Ireland is protected through an EU designation. As long as the designs relate to the same general area, they can be kept together in the registration. And it's a single application, and it results in international publication, protecting your invention in the countries that you have designated. Again, not unlike trademark registration. The next slide then is, there is examination by WIPO. They will examine it for formalities and for the drawings, but they won't examine it for novelty, whether it's novel or not. The international design registration is becoming quite useful since in the post-Brexit era, because we can file with one single application. We can protect the EU, the UK, and also 2 other countries which are important, which are not in the EU, Switzerland and Norway. And we can do it in one single application. However, each country is entitled to raise objections. The US is party to the international design registration, but it would be quite difficult to protect your design through this route, and it would be advisable to do a national application for what they call, or the Americans call, a design patent rather than a design registration. Finally, you'll see on the next slide that the maximum protection afforded by a design registration or an international design registration is 25 years. And in effect, it results in bundles of design registrations, because if an infringement occurs, you have to enforce it in each country. It can't be done centrally. So I think that's, are we going to have another poll here, or no, the next one? Yeah, this is Carl. I think you're going to take this.
Brilliant, thank you, Dennis. So I suppose these are the intellectual property strategy takeaways that we hope you will take home with you today. The first, I suppose, is to be aware of your IP and that of others. To review your IP portfolios with your trademark advisors or your patent advisors, because it is a journey, I suppose, that we should go on together with all brand owners. File new applications if required. Again, if you begin to export, it's important to file new applications in the countries where you're exporting, be them trademarks or others. Review your supply chains, review your existing and new agreements, because they can change. Obviously, if you're, you suddenly are in different markets, and always consult an IP advisor. So here we have a poll. Are you actively looking at international IP protection in your export strategy? Okay, so that's good to hear, that you're looking for international IP protection, and that is very good news. So well done to all those, and anyone who hasn't, maybe it's something that you would consider, and certainly we're always here if you have any queries, and we're always happy to help.
Okay, thank you, Carla. So this is just our final slide. I just wanted to put this up so that people can be aware that there is assistance available and support for SMEs who wish to protect their IP. So the EU IPO has this small enterprise fund, SME fund. So if you just click on the link, which is available on their website, so you can get 50% of the registration application fees and up to 75% of the IP diagnostic scan services, up to a maximum of 1,500 in total. So this would be the likes of searches, initial searches, patent searches, trademark searches. And the IPOI, which is the Intellectual Property Office of Ireland, which is the new name for the Irish Patents Office, it also offers this IP pre-diagnostic scan as well. And also, of course, I would bring your attention to Enterprise Ireland, and Enterprise Ireland have an IP section now, and there are various grants available for small enterprise SMEs to avail of. So there are a number of programs there, and the person in charge of that is Joe Doyle, and Joe Doyle is very helpful for anybody that wishes to make contact with Enterprise Ireland. He's in charge of the IP section. So that effectively finishes our presentation, and I'll hand you back now to Tig, who will wrap it up.
Thank you, Carla, Dennis. That was a brilliant comprehensive overview of all the aspects of IP. I must admit to being slightly hazy on the differences between trademarks, patents, and copyright, but it was very, very, very clear here, and I'm confident companies have everything they need now to start thinking about their IP export planning and strategy, and whether it be within the EU or in several jurisdictions, through the international application and registration. We have plenty of questions to get on, so I'll swiftly move on to the Q&A and begin with some pre-submitted questions. I'll put them out there to both of you and let you tag team the answers. So the first question was, how much does it generally cost to file a worldwide trademark?
Oh, it's very difficult to answer that question, to be honest, because, for example, if you're going to file, say, an international registration and designate, say, 20 countries, there are fees in each country. So it's not something that would really I could answer now, but certainly if somebody is interested and they have an idea of those countries, certainly if they send me an email, I'd be able to give a clearer idea, more meaningful really idea of how much that would cost. But it would be probably difficult to say that now.
The next question is, are there special considerations for exports to and from Ireland from an IP perspective?
So I would say, as far as the trademarks are concerned anyway, you need to consider if you're exporting, have you got protection in the countries that you're exporting to? And if not, that you make sure that you obtain that protection, especially if it appears that country is going to be a country that you will sell, that your business will do well in and that you'll have lots of sales. So I think as far as trademarks are concerned, make sure that your trademarks are protected.
Perfect.
Yes, on the patent side, obviously, you should file a patent application before you export your product to the particular country. But also, you may need to check that other patents are not enforced that may affect the sale of your product. So sometimes it would be advisable to do a freedom to use or freedom to sell search, so that for instance, if you're exporting to the United States, so it may be advisable to do a search in the relevant patents that are enforced in the United States to check that there's not going to be an infringement issue when you export your product to the United States.
Thanks, Dennis. The next question comes from an individual who has online health and well-being programs. They've already started doing business in the USA, UK, and Canada, and would like to know how to protect their online programs. I'll leave that to you, Dennis.
Okay, there are a number of aspects of this. Obviously, the branding of the trademark will be very important to protect, because a program like this can establish presumably a lot of goodwill, and there would be a reputation attached to the program, which could be protected by trademark. This may be difficult to protect by patent. It could, if there's a computer program involved, you cannot protect it by patent. The only protection would be by copyright. So there is copyright protection in the program. So you need to ensure that the program is marked copyright, and any material distributed with the program has the copyright symbol on each page and the name of the company that owns the copyright. But apart from that, and designs may be useful as well if if there are certain design features in the package.
Perfect.
Okay.
The question from the webinar: how does IP relate to listing ingredients?
To what? Lifting ingredients?
Yes. So I suppose it is for food products. Would IP have any relation to the ingredients in food products? Would you need to get any protections in that space?
Well, I suppose it probably depends. I mean, if it's something like the Coca-Cola recipe, then obviously, if it's then it's a trade secret. But I would assume that with most products now, you have to put the ingredients and such on the back. So maybe not. I think in that case, if you're selling some kind of a product, it's probably a trademark that you need to protect the trademark in connection with that product. But unless the recipe is secret, then it would obviously be a trade secret, I suppose. Is that right?
Yeah, I mean, it may be patentable as well if the ingredients are listed, but if the ingredients produce a surprising effect, and not just a purely sort of a recipe like in a cookery book. If the ingredients, so there may be something patentable in that, in which case you have to file the patent application before you disclose the ingredients to the public. You know, if the particular ingredients and the way they interact together causes a surprising effect.
Yeah.
The next question is, how do you check your trademark is free for use and registration?
So that would be done by the searches that we spoke about. So you would, you know, if you want to protect your trademark in Ireland, then we would do a search of the trademark database at the Irish Trademarks Office, and that would tell us then if there is an identical or a confusingly similar mark already registered at that office.
The next question we have, just back to the online side of things, is can a computer app be patented?
No, a computer app, a computer app presents a lot of difficulties in protecting it. As I mentioned, there is a prohibition in the patent system to protecting. You cannot get a patent for computer software or for a method of doing business, or for presentation of information, or what they call as abstract ideas. So in which case the computer app would be protected by copyright. The only way you can get patent protection is if the computer app does something innovative, if there's a technical innovation occurring within the program, where maybe the way the algorithm works to process data in a particular efficient way may be technically different from previous iterations of similar products. So it may be patentable, but it needs a considerable lot of work, and you have to drill down into the actual program and see what's happening in the program and whether there's actually a technical effect taking place in the program other than just a mere presentation of data and the regular processing of data that normally occurs.
Just jumping back to the question on ingredients and how that relates to IP, just have some clarity around that. It's actually with regards to a cosmetic product. So I don't know, would that change the advice?
Cosmetic products certainly, I think, would be patentable, because it's not just a pure list of ingredients as in a recipe. There are many patents granted for cosmetics, and you know, especially when you can have ingredients that maybe never used together in a particular combination that produces a surprising effect. But as with any invention, the patent application has to be filed first before the product is launched on the market.
Perfect. The next question just came in. How much would it cost to trademark a brand name in Ireland, if answerable?
So I suppose you're probably looking at around €1,000 to register a trademark, one trademark in one class in Ireland.
The final question, barring any that pop up in the meantime, is it difficult to get IP protection in China? It's a very popular question with our member companies at the moment. We've various programs in China and trade shows. So we're interested to hear the advice.
Yeah, the Chinese have introduced, they only introduced the patent system in 1980, and since then their patent office has come on in leaps and bounds, and is one of the top IP offices now in the world. And the examination system is very efficient there, and I have got many patents in China, and the examiners are well able to examine the applications. The only question I have on Chinese patents is the enforcement. Enforcement can be difficult in China, and especially if you have to go from province to province. But certainly you can get IP rights registered now in China, and get very high quality work from the patent office, both in patents, designs, and trademarks. But the big question is enforcement, which is always the problem that I have experienced in China.
Yeah, because there'll be lots of companies worried about, even if they are protected, if there was an infringement, about enforcement. But yes, it sounds to be improving anyway. That just about wraps it up for today. I'd like to thank all the participants, Dennis and Carla, for presenting today and sharing their knowledge and expertise on such an important topic for exporting companies. Please don't hesitate to contact McLaughlin Donaldson or us at World Trade Centre Dublin directly if you have any further questions or would like any advice on intellectual property, exporting, selling your products or services abroad. And please let us know if you'd like a recording of the webinar here. Lastly, wish everyone a great weekend and have a lovely day.
Thank you very much. Thank you, Tadhg. Thank you, everyone.